So, Ms. Bernard, any closing argument for Mr. Moore?
Just briefly, Your Honor.
And we're going back on the record on 462, position 14.
Your Honor, of course, we are here for a probable cause hearing, and so the standard is not the justifications or defenses that might be available to somebody for their conduct. The question before the court is, of course, whether the conduct gives rise to the very low bar of probable cause here. And the evidence is clear and uncontroverted that Randall Keith Williams used physical violence against Colton Moore, causing injury to him. There appears to be a great deal of testimony, and from the questioning that we have heard from the respondent, they seem to be wishing to advance a defense that that physical contact was in fact justified in some way because of some order that was perhaps given by one of the witnesses whose subpoenas was quashed and who declined to make himself available to the court. However, the entire basis for their denial of probable cause rests on the idea that there was some sort of legitimate censure or ban in place that would prevent an elected senator from attending a joint session of the General Assembly. There is no such law, Your Honor. There is no such provision. In fact, there are numerous laws which we have cited to you regarding interference with government property, as well as disruption of the House and Senate, that would actually prevent anyone from obstructing someone from entering into the House or Senate. I will go ahead and put on the record now that this entire situation that they are referring to comes from Senator Moore speaking against Senate Resolution 687 on March 14th, 2024.
Objection. Facts not in evidence.
I think it's a reasonable inference from what I've heard, so I'll allow it just as an inference, but it's not a fact for me to consider.
Oh.
But it ties into your argument, so I'll allow it.
Thank you, Your Honor, because there has certainly been no evidence presented of any censure, despite the fact that respondent has repeatedly referred to such a thing. They have repeatedly referred to a ban. They have put no evidence in that, and the only individuals which we have heard from, Terry England and John Burns, who would be able to provide evidence, have been specifically not brought before the court so that they could offer that. So what you have here is one man walking to do his job at the Georgia State Capitol on January 16th, 2025. He is a principled man. He is a man who plans ahead. He is a man who takes his responsibilities to his constituents very seriously. And so when he received a letter from John Burns that was also not put into evidence, but since we're not afraid of the truth coming out, we don't mind referring to it, he actually went and made the effort to try to resolve this and de-escalate it himself. However, it was...
To that argument, we have no burden of proof, and she's arguing that we should have put something in that we didn't. She wants it in. She could have put it in. She didn't.
I'm just saying that they referred to it multiple times.
I'm going to ask y'all not to interrupt each other, if possible. If you do, I'll consider an objection. But Mr. Holloway, you and Mr. Fleischman, you'll have a chance to give your closing argument in just a moment. Go ahead.
And actually, Your Honor, then since I carry the burden of proof, would it be possible for me to complete the argument before the court, as I carry the burden of proof in this proceeding?
Oh, you want to go last, you mean?
Yes, please.
That's fine. Any
Thank you, Your
objection?
Honor.
Ms. Bernard?
Thank you, Your Honor. There is no dispute that Randall Keith Williams used physical force against Colton Moore. He pushed him, he grabbed him, he tackled him, he threw him to the ground, and he caused serious injury to his hand to the point of bleeding, bruising, and inability to use several of the fingers on the hand and continuing nerve damage. The injuries and the damage are undisputed in this case here. And in fact, even the officers make it clear that they observed the same thing. The only thing that appears to be at issue here is whether or not there was any legitimate authority, such as the owner of a Quick Trip would have if he were seeking to criminal trespass someone from coming in. And that is simply not present here. What we have is an elected senator who was seeking to attend to his constitutional obligations, even assuming that this argument that there was a valid ban or censure from the House in place, even assuming that that was true, which it is not, because of course there was no valid vote taken and no action that would constitutionally authorize this, then that would not apply to a joint session in which the House and the Senate are commanded to come together for the purpose of observing the state of the state of the judiciary, or anything else. So in fact, there was no legitimate authority that would allow Keith Williams to operate in the position of the owner of a Quick Trip. In fact, it was Colton Moore who was standing there representing his constituents, seeking to walk peacefully into the House of Representatives for a joint session. He was not pushing anyone. You were able to view the video yourself. You were able to view his hands at his side. You were able to view where his chest is at all times. You saw other people put their hands on him. You saw other people grab him, tackle him, and throw him to the ground. So the question of justification, certainly it can be taken into consideration at the charging level, but at the probable cause level, the very lowest level of simply, is this probably likely to have happened? You know that this happened. You know that Randall Keith Williams put his hands on Colton Moore and grabbed him. A person commits the offense of battery when he or she intentionally causes substantial physical harm or visible bodily harm to another. The bodily harm that Keith Williams caused, that you saw him cause on the video as he threw Colton to the ground with enough force that it could be heard on the other side of the black curtains that had been set up to shield this activity from the scrutiny of the public that was happening in the Capitol. He was thrown to the ground with enough force. He was not wearing shoes that caused him to trip. He showed you his shoes, Your Honor. This was not a situation in which he lost his balance. This was a situation in which he was thrown to the floor and attacked. Of course, Mr. Williams has the right to sit there and remain silent, but he has offered no evidence whatsoever to justify or controvert the physical actions that he took towards Colton Moore. Now, we could sit here all afternoon, and I would be happy to give you the background on Senate Resolution 687, which Colton Moore did not want to have to speak to on the floor of the Senate on March 14th, 2024. He wanted to speak on it in a committee hearing. However, Senator Gooch suspended the rules and brought it directly to the floor, and then brought David Ralston's family over so that they could watch. And then there was still no problem whatsoever with Colton Moore giving a speech and voting no on legislation. And Your Honor, this is what this case unfortunately comes down to. The idea that a senator speaking and voting no on a piece of legislation is such an offensive thing that it warrants a ban and censure and the use of violence against that same senator when he is merely seeking to undertake his constitutional obligations. And you hear the contradictions even between the two different counsel that Mr. Williams has obtained for himself. One states that this is not a justiciable issue that could go to the courts. The other one says, oh, well, I guess he should have gone to the courts to deal with that. So comments on Twitter aside, legal and administrative remedies, at all stages, Colton Moore has acted honorably, truthfully, and with principle and with his with the interests of the state of Georgia in mind. Walking into the House is not a crime. Blocking someone from walking into the House is a crime. That crime was committed by Keith Williams. Battery is a crime. That crime was committed by Keith Williams. Interference with government property, which includes blocking someone, is a crime. And this individual who has been identified as a general counsel and is holding himself out that way and identifying himself as such is not in fact a Georgia barred lawyer. So that goes to the credibility issue as well. So, Your Honor, there are clearly many complicated and political issues here going on, but you can boil it down to what you see on that video, which is one man attacking another man. That man who attacked him is Randall Keith Williams, and we ask that you issue a warrant for battery. We ask that you issue a warrant for interference with government property. We ask that you consider upgrading it to aggravated battery. We ask that you issue a warrant for disruption of the Senate or House of Representatives for his conduct. So we appreciate the law enforcement officers being present and offering their perspective on it, because it does clarify that those physical actions were what were taken. They had been given orders by the office that employs Mr. Williams regarding the actions that were to take place. So again, we're not dealing with a quick trip. What the respondent is asking you to do is say that an elected senator can just be barred for any reason whatsoever, that you can then use violence against him, and then he has no legal recourse as the victim of that violence. This is an extremely dangerous precedent to set. Randall Williams is not a law enforcement officer. He is not somebody who has any training or experience. He is somebody who physically assaulted someone else because he was angry about his vote and he believed he had the authority to do so. He did not have the authority to do so, and we ask that you issue a warrant appropriately. Thank you.
Okay. Thank you to everybody.